Good morning, everyone. I invite you to please have a seat. Welcome back, Virginia. You feeling better? Good. I'm so excited. Hi everyone, I'm Dana McGath, the rabbi here at Temple Emanu-El. It's my honor to welcome you all to our lovely synagogue, and I'm glad you found your way in here. As you know, we're going through a lot of construction out there, so it can be a little bit of a maze. Just so that you know, this is the most important information you'll get today. The bathrooms are back there. Here left behind you if you need to use them. And I just want to take this opportunity to thank our amazing committee for doing such a great job in making this happen. This took a few people, all right, but I want to thank them. Well, this is a very exciting day for Temple Emanu-El because Judge LaDoris Cordell is in the house. She and I share in a couple things. One thing is we're both American Leadership Forum fellows, but I can tell you I've been in this community since '99, and I think she's one of the heroes of this community on so many levels. Read the book, you're going to hear it even more. But when we needed sanity in a variety of different areas, she was the woman that we went to. And she's had to put up with tremendous amounts of, well, misogyny and xenophobia and prejudice and all kinds of different phobias with people. And through all that, she has led and has been an amazing judge for all of us. But I want to thank her especially for the work she's done for this community. It means a tremendous amount to me. I also want to thank, we have an amazing adult education committee, but it's led by the best chair in the world, and that's Len Schreiber. So without any further ado, we have a few of us to talk, and we want to hear from the judge more than anyone else. I'm going to invite Len to share a few words with you. Again, welcome.
Very few words. I just want to welcome everyone. Thank Havurah Zion for their sponsorship of today, and especially Gloria and Shirley and Suzanne for helping put this together. And there are some flyers out about adult education. Please look at them. Feel free to contact me. My email address is on there. Because this is the first of what we hope will be a series of Sunday speakers. And then we have a whole bunch of other adult education that both Temple members and community members are welcome to attend. So I'll be around afterwards. Feel free to ask me any questions. And with that, I'll turn it over to Gloria to introduce the judge. And do you want?
My pleasure. Thank you. Hello, everyone. Good morning. How many are members here? Lots of you. How many are community? All right. This is great. So I'm going to ask you a couple of questions. How many of you have ever been in a real courtroom? Oh my gosh. Not Judge Judy. And how many of you have been in Judge LaDoris Cordell's courtroom? A couple of you, okay. Well, I was in her courtroom about 25 years ago in a counter lawsuit with a tenant. And it started from a small claims court that escalated. And I found Judge Cordell to be just an amazing, as Rabbi talked about, a person with integrity, with listening, with respect. And of course, it didn't hurt that I won the case, but anyway, I was like, oh my gosh, I'm going into this room, this courtroom with Judge Cordell, who then was very famous and very powerful. So that was pretty exciting. Today, LaDoris Cordell finds herself in a different court, and that is pickleball. She is addicted to it and also to yoga. So She's here today with her partner, Florence Keller. Welcome, Florence. Florence is Jewish, and so LaDoris, that makes you an honorary Jew. Yeah. And I could stand here and tell you about all the roles that she's played and all the accolades that she has received. I actually was with her when she received a very prestigious award from the ACLU. But she told me she does not want this to sound like an obituary, and to keep it short. So at this point, I'm going to have the judge tell us about herself, her stories, and I hope that you consider getting her book. Maybe you already have it. She'll be ready to sign some later if you did bring one. And it is my honor to present Judge LaDoris Cordell.
Good morning. Good morning. Thank you so much, Gloria. Thank you to the committee for inviting me to be here with you all. Thank you, Rabbi, for your kind words. And I'm just looking forward to not only talking to you about my life on the bench, nearly 20 years, but also Q&A. If you have questions, comments, this is your opportunity to ask a judge, retired judge, anything you want. So thank you so much. In June 2019, I began on Suzanne, by the way, I have some show and tell for you all. And Suzanne's going to help me. She has some images that I'm going to ask her to put up and to kind of give you an idea. There are no photographs here in the book, so I'm going to give you a sense of the players and some of the things that happened to me during my time on the bench. So in June 2019, I began writing her honor about my nearly 2 decades on the bench here in Santa Clara County. This book is part primer about the world of state trial court judges, and is part memoir about my nearly 20 years on the bench. So I call it a new genre. I call it a primer memoir. And the one and only silver lining for me about this pandemic was that it forced me to stay home and to write. And I wrote generally 4 to 5 hours every day for 1 year. But there would have been no book but for my parents, who, let me go back a little bit. The last 7 years that I was on the bench, for whatever reason, I decided every Friday afternoon to write a letter to my parents about everything that happened that week. So normally I would talk to my mother driving home from San Jose out to Palo Alto, and I decided, and my parents were so interested, because if you're a trial court judge, anything can happen every day. It's just, you never know, which is one of the reasons I love the job. So I started writing letters. I'm not talking emails, I'm talking letters, envelope, postage stamp, and I think, and I'm saddened because in the day today of social media, we've gotten away from letter writing. And I think it's just wonderful. For me, it was a way to kind of unload for the week. So I wrote about the cases that I presided over that week. I wrote the names of the people, because these were public hearings, most of them. I wrote about the decisions I made, and I also wrote about how I felt making these decisions, because these were personal letters to my parents. So after I retired in 2001, I took a trip back east just outside of Philadelphia to visit my parents. And during the time I was there, my mother, who was a very organized woman, pulls this box out of our little room closet, and she said, "What do you want me to do with these?" And I looked, because I didn't make any copies. These were all the letters I had written for 7 years, every week. And it's because of those letters I was able then to write this book. So I want to show you who my parents are. And as Suzanne puts this up, I want to read you something from the book about my parents. All right, this is from the book. The first chapter is called Bitten by the Judge Bug. And I write about how I became interested in becoming a judge. And this is from the book. Lewis and Clara Hazzard had worked hard to provide for us and to ensure that my 2 sisters and I went to college. Their mothers had been the help, domestic workers who toiled for next to nothing, serving wealthy white families who resided in Philadelphia's prestigious mainline suburbs. When my mother, a high school graduate, and my father, a graduate of North Carolina Agricultural and Technical College, married in 1943, they had neither an inheritance nor a nest egg to get them started. What they did inherit, though, was a terrific work ethic and a powerful drive to succeed. My parents would come to own a home and operate Spring Cleaners, a dry cleaning business that supported our family for 40 years. Without those letters, I would never have recalled the stories that are in the book. And I completed the book in July 2020, and it was published a few months later in October 2020. So you will read in the book, if you choose to read the book, you'll read stories about some of these cases, and these are the actual names of the people who were involved in these cases. Never would I have been able to remember this. So when I got these letters, I mailed them back to me here in California, and it took me about 2 or 3 years before I could bring myself to read these letters, and I was stunned by the volume of cases over which I presided, the variety of cases over which I presided, and I just would never have recalled all of these different kinds of cases. So, next one. I was appointed to the bench in 1982 by then Governor Jerry Brown, and making me the first African-American female judge in all of Northern California. And this figure, and that was 1982, I mean, it's a little startling, the first black woman judge. So what you see here in this one is when you become a judge, you don't just get a robe and go to work. You have you have a ceremony. It's called an investiture. And people come, and big deal. And it was a big deal in 1982 because there'd never been a black woman on the bench in all of Northern California. So this is the investiture at Stanford Law School. I'm a graduate of Stanford, and my parents are there, and along with my then spouse and my 2 daughters. And you can see there, the little one, Star, was about a year old, and Sharon was about 6 maybe. And they're now in their 40s, and Sharon, who's standing there, is a lawyer. She is the city attorney for the city of Hampton, Virginia. So that was the investiture, and there's another one, if you'll pull out. So at an investiture, you have to be sworn in. I have to take an oath. All judges have to take an oath, and that oath is to uphold all of the laws of the state of California and all of the laws to enforce the Constitution of the United States. The person who swore me in 1982 is Felton Henderson. He was a federal judge, and he is now taken senior status. He is an amazing human being. There's a documentary about him. Books have been written about him. He is a courageous federal judge, now retired, and he has made just amazing, courageous decisions. So this was the person who swore me in. He continues to be my friend to this day, and he resides over in Berkeley. So after I got sworn in, and this was in May of 1982, I set out to mete out justice, as I noted in the first chapter of the book, untrained, untutored, and totally unnerved. The world of a trial judge is one big drama, which is why the fact that I majored in theater in college was the very best preparation I could have for being, first, I was a litigator, and as a litigator, you're trying to persuade, your audience is the jury and or the judge. Because in theater, that's your job, to make the audience believe whatever it is you are saying or portraying. And then, when I became a judge, then I was the producer-director. The courtroom, as the rabbi said, this is the house. So the courtroom was my house, and I was, when people were talking, I'd tell them when they can speak, when they have to shut up and sit down. do it very nicely, not like Judge Judy. And also telling people, you know, when they can stand up, when they can sit down. It was just really up my alley. I did not know that at the time that I was a theater major, but it all worked out. Anything goes in the courtroom. People lose their inhibitions, and then you just never know what is going to happen. So in her honor, there are lots of war stories from the variety of cases over which I presided. And I presided over, and this is trial judges generally. I call them the people's judges because if you come into the legal system, the very first person you're ever going to meet is the trial court judge. And trial court judges preside over everything. Traffic court, probate, where people were fighting over dead people's stuff, family court, divorces, child support, name changes, adoptions, and by name changes, if you want to formally change your name, a judge has to permit you to do it. Adoptions, juvenile court, both juvenile delinquency, that's kids charged with crimes, dependency court, that means children who are neglected or abused. It is the judge who decides what happens to that child. Foster care, placement maybe with another family member. Criminal cases, the judge decides who gets bail, who doesn't, and sentencing, and then presiding over jury trials. So there's a chapter, just to give you an idea, there's a chapter in the book about probate court, I call it Where There's a Will. And one of the cases in there is about a wealthy inventor, a Stanford business school graduate who died and left his entire estate to Tom, Dick, Mary, and Kim. No last names because they were 4 feral cats. I kid you not. And this is from the book. The Walton Trust, Mr. Walton, provided that $600,000 was to be used to maintain these 4 cats. Now these are feral cats, right? They're out in the wild, but okay. So this is in the trust, right? To maintain the cats, and I'm quoting from the trust, in a most pleasant manner and pleasing atmosphere that as I have been accustomed to give them during my lifetime. I continue in the book, what lawyer came up with that wording? I wondered. The trust also bequeaths $3 million in real estate to 7 animal charities. The 3 lawyers who represented the 7 animal charities contended that the trustee, that's the person who operated the trust, had improperly used the trust assets to pad his pockets. Preferring mediation to litigation, I spent several hours in discussions with the attorneys and worked out a settlement. Most important, I ordered that Tom, Dick, Mary, and Kim should continue to live in the comfort and care to which they had been accustomed. Very rich feral cats. I have a chapter in the book called Bad Judges, where I profile some really bad actors in black robes from around the country. They're astounding when you read what these judges did, and more astounding as to what happened to them. In a nutshell, very little. And yes, in the chapter Bad Judges, I included myself. Why? Because some cartoons that I had drawn did not sit well with a few of my colleagues on the bench. I donated cartoons. These are legal cartoons. I'll explain and actually show you in a second. I had drawn these because just from being a kid, as I explained in the chapter, I always liked to draw. Doodle, cartoons, and also do some serious work, artwork. And I donated these legal cartoons to a nonprofit called Legal Advocates for Children and Youth. LACY is the acronym. And their job as a nonprofit was to provide legal representation for children. Children can't afford lawyers, so this is what this organization did. And so what LACY did, they took these legal cartoons and they published them in a calendar. And my first calendar came out in 1998, and it sold like crazy. The foundation made $12,000 so the next year, there was like more, we want more. So the purpose, the idea was to try to figure out the legal term that was depicted in the cartoons. So I'm going to read you from the chapter Bad Judges, just to give you a sense, and then I'm going to show you some of these cartoons. Okay? And then you'll maybe understand, because I don't understand to this day why I got labeled a bad judge. But here we go. This is from the book. The drawings depicted judges, lawyers, jurors, and me in humorous situations that illustrated common legal terms. In the first 3 months of 1999, this is the second now calendar, the calendar sales generated the first 3 months more than $9,000 for Lacey. In June 1999, I received a letter from the Commission on Judicial Performance informing me that an anonymous complaint had been filed against me, alleging that my cartoons, 1999 cartoons, 98 seem to be okay, the cartoons, quote, impugned the integrity, impartiality, diligence, sobriety, and competency of the judges depicted, potentially eroding public confidence and respect. Never mind the long and revered tradition in this country of parody and satire of our legal system, and by such famous cartoonists as Charles Bragg and in France, Daumier. And never mind the protections of the First Amendment. So here's what all the fuss was about. So let's show, there you go. So what you're gonna see first is the cover of the 1999 calendar. And as you can see, and I have the actual calendar here, just to give you a notion. And the cartoon on the front is also a cartoon within the calendar, okay? So the idea is, what's the legal term? So I'm gonna give you this first one. And if you look, so you see legs dangling, right? And you see the rope, so it's a hanging judge, right? Come on. The problem with this, apparently was I put, as you can see, golf shoes on the judge. Complainants didn't like that. All right, so let's look at the next one. All right, so that's the cover. This one got a complaint, and I'd like you all, come on, you can figure out what the legal term is. All right, so and you might want to bring it over, let people see it. So there's a judge, he's smiling, and he's holding a bottle of Johnny Walker Red alcohol. And he's in his chambers, and as you can see, he has a calendar behind him, the month of July, and every day on the calendar it says golf. And then there's a line at the bottom for the last week of July, and it's a line that says retirement, and then the days after it says golf. Okay, all right? So what is the legal term depicted here? So it's a judge holding the Johnny Walker Red. I'll give you this one. You ready? Take the fifth. Take the fifth. Come on, these are fun. Right, Ms. Chabelle, lawyer in the back. These are fun, right? Okay. All right, let's try another one. This one you will absolutely get. Take your time. Take your time. Now, if this looks like Newt Gingrich, it is. Right? And so, okay, now what's the legal term? What is he looking at? Okay, think legal. Cross-examination. Thank you. Get the so he's examining the cross-examination. Got it? Very concrete. All right, let's do one more. This one got me in trouble too. And this is one where I depicted myself. I'm at the bench, and as you can see, these are all people in the courtroom. You might want to bring it, show it over here too. People in the courtroom, and yeah, you can come over, fine. And they're all they're doing things with their arms and waving around. So what's the legal term? Okay, I'm going to give you this one. You ready? Make a motion. Okay. All right. All right, so what happened to me? I drew these cartoons, donated them to a nonprofit for kids, very concrete, haha, very funny. I'm going to leave it as a teaser because you will be shocked about what happened to me. And I will just tell you I had to lawyer up. Okay? Just let you know, and that's a little teaser. All right, moving on to another subject. Juries. How many of you have served on a jury? Whoa. Excellent. The right to a jury trial is enshrined in 3 places in the United States Constitution. Article 3, the 6th Amendment, speedy trial in criminal cases, which is mandatory on all of the states, and the 7th Amendment for juries for civil trials, which are optional for the states, but every state requires that there can be a jury trial in a civil case where people are suing each other. Now, I loved jury trials because I'm a people person. And I saw these trials as ways to introduce people to our legal system in the hope that jurors would have a good experience and feel good about our legal system. If anyone you know wants to be, as a lawyer, wants to be a trial court judge, if they're not a people person, discourage them. If you don't like people, you should not be a trial judge to begin with, and certainly not a judge who presides over jury trials. Now, jury selection, I found fascinating, I found it amusing, and I found it annoying. When people who saw jury service akin to the plague did their best to get out of jury duty. So I can understand why many people want to avoid jury duty. There's the time wasted where you're just sitting around for hours, not knowing what in the world is going on up in the courtroom. And there's the compensation, or lack thereof, for jurors. This is from the chapter in my book about juries called Thank You for Your Service. Okay. Juror fees range from a high of $50 per day in Arkansas, North and South Dakota, and federal trials, to $5 a day, New Jersey and Kentucky, to nothing, Delaware and South Carolina, and everything in between. California is near the bottom, coming in at just $15 per day, not counting your first day of service. Okay? When full-time employees are called for jury duty, only 8 states and the District of Columbia require employers to pay their regular wages during jury service. So there's a compensation issue. And I'll go back to here. So in the last chapter, next to last chapter of my book, it's called The Fix. And I recommend 10 things that all of us can do to make this legal system more fair and more just. And in The Fix, I propose that the states establish jury funds to adequately compensate jurors, and that large employers like Google, Facebook, the ones that use the courts all the time, that they be required to continue to pay their employees who serve on juries, because there is no such requirements, and these big companies generally do not do that. All right, so let's talk about something that's happening right now, and that's judicial elections. If you've looked at your ballot, there are some appellate court justices on the ballot, and you have to decide if they should be retained or not. Okay? So that's okay. No. That's all right. It's okay. I'm not going to hold you in contempt. So retention means, should these justices, these are appellates, so you're going to see on the ballot Supreme Court justices and 1 or 2 appellate court justices. And these are courts that review what trial judges do. Right? You have to decide if they should be retained to serve another 12-year term. Okay? Trial judges in California serve 6-year terms. Right? So there's no contested elections for these appellate court justices in California. It's only an issue whether or not they should be retained. Okay. But for trial judges, contested elections happen all the time. So I have a chapter in the book called Judges for Sale. And I let readers know that judicial elections were first instituted in this country in the late 1770s and the early 1800s, when the territory of Vermont, not yet a state, and the states of Georgia and Louisiana used judicial elections to fill seats on their lower courts. The first state to adopt judicial elections was Mississippi in 1832. In the rest of the states at the time, governors appointed judges to lifetime terms during good behavior. I was able to secure a seat on the Superior Court, and let me explain. There's only one trial court in California, that's the Superior Court. So above it, an appellate court, and then the Supreme Court. This is all within the state. Okay? Back when I was on the bench, Jerry Brown appointed me in 1982, I was a trial court judge on the municipal court. So there were two levels of trial courts in California, municipal and then superior. Today, and in the late 1990s, the municipal court and the superior court were consolidated. So there's no longer a municipal court, but at the time there was when I was on the court. So in 1989, I ran for the Superior Court here in Santa Clara County, and it was an open seat, meaning the judge who had been on the Superior Court had retired. And the timing was such that the governor could not appoint. It was subject to an open election, contested election. So in the chapter, so this is the next one, and it's kind of sticking out a little bit because it's a little shorter, right there. You got it. So in Judges for Sale, I describe my election experience. And this is my second investiture because I won that election. This was in June 1988. Okay? So I describe in that chapter my experience running for a seat on the Superior Court. And I would not wish that experience on my worst enemy. Well, maybe a couple of people. But first of all, why? Why? It takes a lot of money to run for a judgeship. So back in 1988, I raised about $70,000, and today that would be about $150,000. Mostly that money came from lawyers, many of whom appeared in my court. So think about that. I mean, there's just a kind of a conflict right there, right? You gave me money and you're presiding and I'm going to, not good. So that's kind of a conflict built into the system, right? But that $70,000 that I raised, that is a pittance compared to today's elections. So I'm going to read from the chapter, Judges for Sale. According to the Brennan Center for Justice, which is located in New York, 1/3 of all elected justices, now remember justices are the words we use for the appellate and the Supreme Courts. So these are state courts now. 1/3 of all state elected justices currently sitting on the bench have run in at least $1 million race. During the 2015-16 Supreme Court against state Supreme Courts election cycle, political action committees, social welfare organizations, and other non-party groups engaged in a record $27.8 million outside spending spree, making up an unprecedented 40% of overall state Supreme Court election spending. Unsurprisingly, 56% of that money was contributed by lawyers, lobbyists, and corporate interests. And after the 2010 U.S. Supreme Court decision in Citizens United, allowing an unlimited flood of money into political campaigns, the floodgates to state judges' campaigns opened as well. And there's more. As the influence of money in judicial races grows, so does its impact, and this is really what gets me the most, its impact on judicial decision-making. Again from the book, Kate Berry of the Brennan Center for Justice analyzed 15 years of television advertising data for state Supreme Court elections to gauge the ads' impact on judicial decision-making in criminal cases. Generally, the ads attacked judges for being soft on crime. And for me, that means showing compassion, showing mercy, when it's appropriate to do so, but it's seen as a negative, or praised the judges as tough on crime, meaning death penalty, given life, and that tended to resonate more in these ads. 3 of the key findings were, 1, the more frequently ads aired during an election, the less likely state Supreme Court justices were to rule in favor of criminal defendants. 2, Closer to their re-elections, trial judges in Pennsylvania and Washington sentenced defendants convicted of serious felonies to longer sentences than normally imposed for those crimes. And 3, trial judges in Alabama imposed death sentences more often in election years, sometimes overriding life sentence verdicts handed down by juries. Judges are not politicians. Politicians make promises to voters to appeal to whatever it is their constituents want, and that's fine. But unlike politicians, judges are independent. The only promise that judges can make is to adhere to the law, to legal principles, and to constitutional precedent. Judges are held accountable by appellate courts who can review their rulings and reverse their decisions, by disciplinary commissions, and by properly run recall elections. So it is my view that judicial elections should be replaced with independent nominating commissions that are bipartisan, that are appointed by diverse stakeholders, include non-lawyers like you all, and have clear criteria for vetting candidates. And I think that that process should be open, should be transparent, with publicly available data about the diversity of applicants and the nominees. But until we rid ourselves of judicial elections, which is probably unlikely, we need to do a better job of educating voters. I can't tell you how many times, and it's happening right now, I get emails, I get phone calls like, there are these judges on the ballot, who do I vote for? Who are they? What are they like? What are they? And I get it, because there's so little information we have about people who have so much power over our lives. We want to have an informed electorate, but we're not informed when it comes to judges. So there are several, as I said, California justices on the ballot now, where it's a retention, not contested. You have to decide yes or no. We need meaningful voter guides that include profiles of these judicial candidates. And when we do have those profiles, generally they're written by the candidates. They're just going to write what's good, what they think is good about them. We need to have more information on their backgrounds. The Leagues of Women Voters have chapters. They should be holding forums that with these people who want to be retained or in contested elections, the candidates, people who want to be judges, so that we can hear them and see them. And in addition, one of the easiest things to do, that we all should do, is go to court and look and observe the judges. So if there's a trial judge who wants to stay on for another 6 years, go sit in that courtroom. Those, and why people say, well, I don't know, it's going to be scary. No, no, no. Who pays for the courtrooms and who pays the salaries of everybody in that courtroom? You do. We all do, the taxpayers. Those courts are ours, and they're generally open to the public. So you go in and you sit and you watch. What's the judge's demeanor? What kinds of cases? How is this being held? So there's so much we can do. We rarely do it. We don't go step in a courtroom. Do it. That's how we get the information that we need. So I'm going to give you a little teaser. So just keep that a second. I'm there, my second investiture, because I won that election in June 1988. And maybe some of you actually voted for me in 1988. It was a contested election. And I ran against a white male prosecutor who was just intent on just slamming me, everything from how I wore my hair to everything, and labeled me, you're a Rosebird clone, whatever. And I spent, as I write in that chapter, Judges for Sale, such little time talking about who I am and what my view of the law was, instead of defending myself and also then having to say, okay, I have to tell you this about my opponent. But then I won, and I won decisively in June 1988. So this investiture, I'm being sworn in, right, this is my second one, by Judge Peter Stowe, and he was the presiding judge of the Superior Court. I write in the book about that whole experience, but here is the question. I won in June 1988, an empty seat. That investiture didn't happen until January 1989. Why could I not officially take that seat for 6 months? The answer's in the book. It will shock you. Let's just say it involves a governor. Okay. All right. This is how I began the chapter in the book called J'accuse, Judges Under Attack. There is frequently no warning or signal that a judge's decision is destined to blow up in her face. It could be her umpteenth sentencing decision in her umpteenth criminal case, but for whatever reason, one decision takes on a life of its own with disastrous consequences. That's what happened to Santa Clara County Superior Court Judge Aaron Persky. In 2016, Judge Persky presided over the criminal trial of a 19-year-old Stanford freshman who was charged with sexual assault of a 22-year-old woman, a college graduate. Both were at a fraternity party on the campus, and both were highly intoxicated. A jury convicted the student who, before he was even charged with a crime, had been expelled from Stanford. After Judge Persky sentenced the student to 6 months in jail, the recommended sentence by the probation department, all hell broke loose. He became the target of a recall campaign coordinated by a female Stanford law professor who has, to this very day, never passed a bar exam, never represented a client, never had participated in a trial, and never tried a case, and had absolutely zero background in criminal law and procedure. She was outraged that Aaron Persky had not imposed a state prison sentence and started the recall against the judge. Now, what the recall campaign deliberately ignored was that the punishment handed down by Judge Persky also involved ordering this 19-year-old to register as a sex offender for the rest of his life. Before the recall campaign was over, the name Persky would become infamous throughout the country and beyond. I became a spokesperson on Judge Persky's behalf in opposing the recall because the recall campaign, for a number of reasons. One, lied about Aaron Persky's track record on the bench, because the sentence he imposed was within his discretion and entirely lawful. Might be controversial, it was entirely lawful. And because the judge, I spoke out, he was not legally permitted to speak publicly about the case because of the rules of, it's called judicial canons, the rules of conduct. He couldn't say anything. So I became his spokesperson. Not because he asked me, because I stepped up. And most importantly, I spoke out because that recall posed a threat to judicial independence. Aaron Persky was eventually recalled, supported by an infusion of at least $3 million, most of it from outside of California. Judicial independence. These two words have never been more misunderstood, distorted, and anathema to so many people. Yet judicial independence, as I write in the book, is critical to maintaining our democracy. Judicial independence was recognized in the Declaration of Independence when the Continental Congress penned its 27 grievances against King George III, writing, and this was the grievance about the courts. He has made judges dependent on his will alone for the tenure of their offices and amount and payment of their salaries. So what are we to do? How do we ensure that our state court judges maintain their independence? Federal judges don't ever have to worry about this. They're appointed for life and they can't be recalled. This is a serious issue because if we lose our independent judiciary, we lose our already fragile democracy. The answer that I propose in the chapter called The Fix is to not abolish judicial recalls, no, keep them, but strictly limit judicial recalls to instances of judicial malfeasance or failure to perform the duties of the office, or to judges who have been convicted of serious crimes. I'm not just making this up. That is the way it is done in Georgia and Montana. Recalls in these two states can never be based on a judge's lawful decision, no matter how controversial. And in my view, that's how it should be done in California. The recall provision in the California Constitution is just one sentence. And it basically says that all elected officials are subject to recall. What it does, it lumps judges in with politicians. And as I told you earlier, judges are not politicians. So I propose in the fix that the Constitution of California, we keep that provision in, that elected officials are subject to recall, but that we add a provision that basically says, with the exception that judges, to be recalled, have to fall into one of those three areas, as it does in Georgia and Montana. So the revision of California's recall system would require an amendment to the California Constitution. And you may think, oh, easy for her to say, amend the Constitution. The California Constitution has been amended more than 230 times. This is something doable in our lifetime to preserve our independent judiciary. All right, I'm about to wrap up. Charles Hamilton Houston was a brilliant lawyer. When he started his law practice in 1924, it was he who pioneered the idea of using the Constitution to promote racial justice. The grandson of slaves, Houston was born in Washington, D.C. in 1895. He went to Amherst College, and after serving in the Army, he attended Harvard Law School, becoming the first black member of the Harvard Law Review. He was a teacher at Howard Law School and later became the dean of Howard Law School. And one of his students at Howard was Thurgood Marshall. Charles Hamilton Houston devised a long-range strategy that ultimately led to the U.S. Supreme Court decision in Brown versus Board of Education that declared segregated public education was unconstitutional. Houston died in 1950, 4 years before the Supreme Court decided Brown and made his vision a reality. Houston was fond of saying to his Howard Law students, a lawyer's either a social engineer or a parasite on society. And by being social engineers, I think that Houston meant that lawyers should always be about the business of making a difference, of using our legal acumen to make the world a better and more just place. And that could mean being a public interest lawyer, or being a corporate attorney who takes the time to do pro bono work for worthy causes, or being a lawyer in your own practice who volunteers in the community, or a retired judge who uses her time to make the criminal legal system more just. And by the way, I don't say criminal justice system, we're not there yet. There's much to be done to make it just. It's a criminal legal system, but it's a work in progress. In the final chapter of my book, it's called In My End Is My Beginning. And I undertook a pro bono case, the case of a young woman. So I'm going to read you just a little snippet, and again, it'll be a teaser. Get this. All right. Okay. Bear with me a second. Got it. It was 2:17 p.m. on September 8th, 2009. I had been retired from the bench for 8 years. As Judge Peter Espinoza entered his Los Angeles courtroom, I rose and stood next to Kelly Turner, a black woman in her early 40s. The judge took his seat and said, "This is a hearing on a writ of habeas corpus. I'm in receipt of all of the pleadings. Obviously, they've been reviewed in preparation for today's hearing." 3 years earlier, 2006, I had written an op-ed against California's draconian three strikes law for a local newspaper. It came to the attention of Montel Williams, host of a popular national television talk show based in New York City. I accepted his invitation to appear on the show, and in September 2006, I went there and talked about my view of the law. The other guests on his show were two black women whose sister, Kelly Turner, was in her 11th year of a life sentence for a third strike, possession of a stolen check in the amount of $144. So, I set about, after I left New York and came back, I just couldn't get this out of my head. So as I write in the book, I decided to go see and meet this Kelly Turner, who was in prison in Chowchilla. So at the time, she was in her 11th year of a life sentence. In a little more detail, she had gone to Nordstrom's with a stolen check and tried to buy something worth $144. So I go to the prison, and you can't just go to the prison, by the way. If you want to go to the prison, you have to, the inmate has to put you on a visitor's list. So I had to enlist her sisters to get me in contact with Kelly, who then put me on the list. But then you have to apply to be a visitor. I did not go as a legal person. I went as a non-legal person as a visitor, because I didn't know what I was going to do. I just knew that I had to do something. So I was on, I had to apply. It took a few weeks, and finally I'm approved to visit. If you ever visit a prison in California, do not wear red, do not wear blue, do not wear jeans. There are all kinds of limitations, so I wore black. And I went there. I met Kelly Turner, and we sat and talked in this huge room. It was about a little smaller than the size of this room, but a much lower ceiling, so the noise was loud because there were a lot of visitors. This was a women's prison, so there were kids running around. It was very depressing. And I sat and met Kelly for the first time. The last thing I said to her, as I headed out, I said, I'm going to see what I can do to try to get you out. And I didn't know why I said it, because I had no idea what to do. So I drove back, 3 hours back, and then started working. So I'm going to pick up the book. I enlisted a San Francisco corporate attorney, Roy Bartlett, as my co-counsel. And then I recruited as experts and advisors a forensic psychiatrist, a highly respected retired appellate judge, an equally respected appellate attorney, all of whom donated their time to this undertaking. So it was Roy and I who had to write up and come up with this writ, a petition for a writ of habeas corpus to figure out a way to get Kelly out. Back to the book. In August 2009, after more than 2 years of researching and writing, Roy and I completed a petition for a writ of habeas corpus, a request for Kelly's release due to a sentencing error, and lodged it with the Los Angeles County Superior Court. By then, Kelly was in her 14th year for possession of a stolen check. So we showed up in court. I write about in a little more detail what happened. I hadn't seen Kelly for 2.5 years. So I went to court, and Kelly was there. And as a result, the judge granted our writ, and Kelly was released. So I'm going to show you his photos. This was taken in court right after the judge allowed her release. And I'd like you to walk it around. So I want you to, let me explain. On the top, there am I with Kelly, and she's sitting there, she's in handcuffs. They still wouldn't take those handcuffs off. And the person sitting with her is the prosecutor, who did not oppose our writ for a petition of habeas corpus. It was so well done. And on the bottom is Roy, the attorney, the corporate attorney, who volunteered. He said, I want to do something other than this corporate work. So he worked with me. He had never done this kind of case ever, criminal case. And we put together a petition. It was my best legal writing I think I've ever done to free Kelly. So this is what freedom looks like a year later. Kelly and her 2 sisters. Kelly's in the middle. This is what freedom looks like. From handcuffs to freedom. And it's Kelly a year later with her sisters. Isn't that great? And she's doing great, by the way. She lives in Central California, driver's license, passport in Italy, got married, got a dog, and recently got an award from the State Probation Department for her work with children. This is important. This is what freedom looks like. She's done well with her time now. Okay, so before I end, I have to talk about something really important, my hair. My hair. So, you pull the next one. There we go. All right, I want you to see this. So I wore my hair in these various styles because I could. With this kind of hair, you can do all of that. And you don't even see the braids and all of that, right? We can do all this with this kind of hair. So I wore my hair like this also because I wanted, remember, this is in the 80s and the 90s. And actually I want to show you. So the bottom middle, that's 1982. Straight hair, right? Then if you look to the left, 1988. I'm now in the Superior Court. The hair is shorter, got some gray in there, right? And then it's like I can be me, whatever I feel is me. So I go to dreads, short dreadlocks. You see the box with a fade, and then the hair gets shorter, right? So I wore my hair like this, thank you, because I wanted to send a message that yes, judges can look like this. I use my hair to bust stereotypes. When I walk into a courtroom, they see the box, or they see the people like, what? It's like, get over it. Judges can look like this and do good work. And when I look now and think about how I wore my hair, I was way ahead of my time. Why? In 2020, California legislature passed the Crown Act. And this is a law now in California that says one cannot be discriminated against in the workplace by how you wear your hair. And this came about, why? It came about because of the rampant discrimination against black women in the workplace for wearing braids or wearing a wig, whatever. So I guess, in a way, I was kind of ahead of my time. And one more thing about the hair, and this is a secret, actually. Oh, let me show you one more. There's a second hair one. So just to show you the contrast, this is me, third year in law school at Stanford. Just have to show you. Rivaling Angela Davis's hair, right? This is it. Being me. Now, I could not run for a judgeship with hair like that. No, that wasn't going to fly. So I had to, straighten it and do what I needed to do. So this is a secret about the book. Some of you have hard copy, and it is out in paperback. The standard in the book world is that when there's a book out and there's a photograph on the cover of a book, always on the back flap, or if it's a paperback in the back, there's the credit for the photographer, and there's a credit for the person who does the jacket design. So when I was sent this to look at by the publisher, which was Macmillan, I was like, and they're like, what do you think? I said, well, that's great, but I want another credit. And my editor's like, what? I want a credit for Rabia Zara. Who's Rabia? She does my hair. All these years, all those hairs, that's Rabia. And I said, I want a credit. So my editor says, no. In the book world, that does not happen. It's the photographer, jacket designer. Hair credit is in magazines. And I said, well, who made that rule? And so we went back and forth, and finally she said, okay, so you'll see a third credit, and it's for hair. This is the only book in the world, that has a credit for hair. So I'm hoping it sets a precedent and opens another door. So I want you to see three people. This is going to be the final one. Rabia, I want you to see who this person is. She just cut my hair a few days ago. It was a little too short, but it's all right. And also, I write in the book about Benita. Benita was my bailiff for 20 years, and Olga, my clerk. So we were a team. We were a black and brown lady courtroom. So I'm going to show them. So Rabia is on the left, and that's Rabia Zara. And she just got teary when I showed her her credit in the first ever book that has a hair credit. Right? And that's Benita and Olga, who were with me on the Superior Court the entire time. And I write about them in the book, about Benita. We continue to be close friends. She lives in San Jose. And she's retired and a fabulous award-winning quilter. All right, so finally, I want you to understand but I believe that there is much that is good about our legal system. The very principles that are the foundation of the system and our nation are the best in the world. That all are created equal, entitled to life, liberty, and the pursuit of happiness, that everyone has a right to a speedy trial, a right to a trial by jury, a right against self-incrimination, the right to due process. The problem, you see, is in the implementation. And I leave you again from the book. Created by propertied, slave-holding white men, the system did not envision women, people of color, LGBTQ individuals, and poor white males as beneficiaries of the principal constitutional guarantees of due process, equal protection, and fair trials. As a result, judges impose sentences that populate our jails and prisons with disproportionate numbers of black and brown people. Prosecutors use peremptory challenges with abandon to whitewash juries, and our state and federal benches are primarily the province of white males. These are the consequences of a legal system predicated on exclusion. So our challenge for every one of us is to ensure that these wonderful principles that underlie our legal system are applied equally and fairly to all. So I leave you with the final passage from Her Honor. Judging has been the most fulfilling of my various careers. For nearly 20 years, I wielded power over the lives of thousands of people. And for nearly 20 years, I did what I believe to be right. While it is up to the next generation of voters, politicians, activists, lawyers, law professors, and judges to continue to clear the path to a more perfect union, I refuse to give up on our legal system, and I will never give up on our judiciary, and hopefully neither will you. Thank you. Thank you so much. So we have a little bit of time, Q&A, comments, questions, anything at all.
Just raise your hand, and if you could speak right into the mic, because this is being recorded, so.
This isn't.
Here.
And didn't she do a wonderful job with the images, putting them on easy? Thank you so much.
I read your book and enjoyed it very much. And I was really taken with the difficulty that judges have in juvenile cases. And I was just wondering, I realize it's not your case, but just wondering what you think about the verdict, the jury verdict for the Parkland shooter who received just recently from the jury, received life in prison.
So I have a chapter in the book that starts off talking about juvenile cases, and again, juvenile delinquency, so these are criminal cases. So I'm getting a lot of feedback. So juveniles, if they're tried in juvenile court, are not entitled in California to a jury trial. So if you have a 16-year-old who's in juvenile court, or a 17-year-old, and you have an 18-year-old who's in adult court charged with the same crimes, the 18-year-old gets the jury trial, the 17-year-old does not. I have an issue with that, and I talk about it in the book. So the Parkland case, this juvenile was tried in adult court. So could have been tried in juvenile court, or was not. That decision is left in some states entitling to the prosecutor. In California, that decision is now left to the judge. So the prosecutor puts forth a case about why a juvenile should go into the adult system, which means the juvenile could be subject to a life sentence. And then you have a defense saying no, and it's up to the judge to decide. And there's criteria set out as to where the juvenile should be tried. So in the Parkland case, the juvenile was sentenced to life. I don't know if it was without parole or with parole. I don't know. I'm sorry, do you know somebody? No parole. So basically, the system said to this person, and it's not a question of whether or not he did the shooting. That's not an issue. The system has said, we've given up hope on you forever and ever. You're never getting out, and that's it. So the issue becomes, for people, is that a good thing or not? Should someone who did such a heinous thing be punished? Of course. The question is, if it's a juvenile, given all the factors, and I can't remember all the factors about this juvenile, the question is, should we say, you're out of here for the rest of your life? Do we give up hope on the juvenile or not? It's a tough call, and eventually, in juvenile cases, generally it ends up being up to the judge. In some states, once the jury has decided, that's it. So I can't give you a response other than to say, my view generally is that I do not want a system that gives up on young people, even who have committed heinous crimes. I just believe there's hope. And there are some, however, and I will tell you, there are some people who are so disturbed, so messed up, that if they are in society, they're going to wreak havoc. I understand that, but that is such a small percentage, especially of juveniles. So that's just my viewpoint, and you can, it's fine to disagree. That's fine. We can disagree and talk about it, but I encourage you to read the chapter and look at the issues that I had to deal with when I start off the chapter talking about a young man here in San Jose. He was maybe 15, and he killed his brother. Okay, got to think, but you have to know, again, the facts and understand what precipitated and then what I had to do. And then I write about another case where a 15-year-old girl, I convicted her of felony murder. And the question is, well, what about that? Well, it's in the book. Again, these are interesting, very tough issues, but I want you all to understand the TV judges you see, all this stuff on TV, they make a mockery of the system when the work that trial judges do is so hard and so serious, and we need people who take it that way. Every year in the United States, 82 million new cases are filed in our trial courts. There are about 37,000 state trial court judges in this country who have so much power over our lives. So that's why it's so important to be informed. Thank you for your question.
As a follow-up to that question, I think the issue in Florida was not whether he should get life versus some ordeal period, but rather should he have received capital punishment.
Got it, the death penalty. And I as I write the book, I preside over every kind of case, but I refuse to preside over a death penalty case because I don't believe in killing people. I don't. And people have said to me, well, what if somebody were to kill someone in your family? And I'd say that would be horrible, but I wouldn't want to kill that person. It's just not, that's just not me. I did get death penalty cases assigned to me, and I refused to take them. And it was not a problem because there were a lot of judges on our bench here in Santa Clara County who loved death penalty cases. We had one judge who would always write a happy face after we signed the death warrant. But that was the mentality. That was the mentality, and it was very punitive. We've become a very punitive society. And this is what I've told you. When I did not give a maximum sentence to the 15-year-old girl I convicted of felony murder, I caught hell. Newspaper, Mercury News, judge lets murder her. And that's not true. I did what I did, and I explained the reasoning as I do in the chapter, but it doesn't mean that I didn't catch hell. And had I done that back today, with social media, likely I'd been the subject of a recall. I could see it happening. It's very hard to be a trial judge today in the era of social media because everything gets so quickly distorted. You see sound bites and it's, no, that's not what happened. It doesn't matter. It's happening not just in our legal system, it's happening everywhere, as you know. Just put it out there. People, that's where I get my information. Well, that's very sad. Very, very sad indeed. So it's scary times. Thank you for the question. So in order to do this habeas petition, we also had to say, here's the plan for when she gets out. So we had everything lined up. She had family members. There were people in the community. So good question. We had to do all of that. And that's why she succeeded. That's why she's done so well. Thank you. Bring the microphone around. This one in the front, and then we'll get you.
Yes, can you speak on the distinction between justice and vengeance?
Sure, sure. I believe that a legal system based on vengeance is a system that is flawed, deeply, deeply flawed. So vengeance should be no part, in my view, thinking when a judge imposes a sentence. So then you raise the other issue, justice. I don't think, for example, let me give you a terrible case, a murder case, and I presided over murder cases. I don't believe that you can really do justice in the sense that the person's been murdered and we've caught the person. I believe in the system holding people accountable for their actions that harm other people. So in that sense, vengeance never ever entered into my thinking. Was I really pissed off when I had people come into my court charged with awful crimes like rapes and murder? Yes, of course I was. And yet I'm told by the law, you presume that person charged with all this innocent until such time as the jury says. But when it came time to impose sentencing, and I have a chapter in the book about sentencing and about discretion, what's all involved in that, and my thinking when I had to figure out what to do. For me, and I think it's wrong for judges to say, I'm going to this is all about vengeance. No, it's not. We are told that we have to balance a lot of things, that the rights of the victim, the impact on the victim, but we also have to look at the background and history of this person who committed these crimes and put that together. Am I doing the job to hold that person accountable for what that person has done to harm other people? And I also have to look ahead. Is this person going to be a problem? So that determines how much time I impose. I will tell you, in the book I wrote about a man that I had to impose a life sentence on under the 3 strikes law. And it tore me up. I did not want to do it. He didn't deserve it, but I didn't have the wherewithal to not do it. In other words, the law is narrowly drawn and that judges have some discretion, but I knew that if I were to do what I wanted to do, that I would not be complying with the law, a law that I did not like or support. But the issue is, when you saw me take that oath of office twice at my investitures, I took an oath to uphold all of the laws, not just the ones I liked. So this last case, because I've handed down 8 life sentences, some of which I'm okay with. I didn't do it happily, but I'm okay with it. That person just did not need to be back out in society. But there was some where I was not okay with. So this last one, that was it for me, and that's when I decided I was going to leave the bench, because I could not just continue to do this and help contribute to this mass incarceration of people of color. Which is why then I said, okay, I've let that go. I'm not a quitter, but I did retire and decided, what can I do now outside? How can I help change the system outside? So for Kelly, I did. It was one person at a time. But that's another reason I wrote the book, to energize us. Look at this, understand how this system works, and that's why it's primer, and then figure out, okay, there's some things here that are broken. What can we do to try to fix this stuff? So this isn't a book about complaints. It's a book about experience, informed experience, and then putting it out to you all to say, let's see what we can do to make this system better.
We have a question over here.
Sure.
So we do make that.
One second, we have one up here. She's had her hand up for a little while. This is Gloria. Is that right?
Yeah, I just commend you so much for you speaking like this and writing a book like you've written. But I think you should be speaking at law schools all around, anywhere, not just California. People who go to law school, they have their law professor and they learn about the law, but you've spoken about such diverse ideas, and I'm wondering if you do that, because it would be wonderful for students to hear you all over.
Thank you so much. I would love to do a law school tour. When you're in law school, you learn theory, and your professors, many, if not most of them, have no real world experience. They don't. So they can talk about it. But come on, this is the real world. This is what is happening. So what I would love, my dream is that the deans of these law schools all around the country would say to their first and second year law students, because third years think they know everything, so it's kind of, they would provide them with this book. And then I'd go to these law schools and we'd have these discussions to help inform them about the real world here. So if you have ideas about how to make that happen, I've already done a talk at Santa Clara. But there are schools like my own, Stanford, no one has asked, I'm trying. They should be buying this book, and then I go and do this law school tour. So you've read my mind, and if people have ideas about how to make it happen, let's do that. Thank you.
I think we'll do one more question.
Whatever you want.
Just
I love Q&A. I think it's great. You all are wonderful. So.
I ask because I haven't actually formed my opinion yet. I'm wondering how you feel about expanding the Supreme Court.
Okay. So thank you for the question. This book is focused on state court judges, right? The Supreme Court is federal. They're appointed for life. That, by the way, they have no disciplinary body. They just kind of discipline themselves, which is ridiculous, which is why Clarence Thomas will not declare a conflict of interest, because his wife Ginny's gone rogue, and you know they're talking to each other. You know this, right? And there's no way to compel them. That's outrageous. I write in the book about this and actually quote a statement from Elena Kagan, which shocks me, and say, you know, we really don't need that because, you know, we're us. We can take care. No, any system that does not have a way of checking the checks and balances, you know, they can go rogue. And I call them the Gang of Six. This is my belief. The Gang of Six on the court, they're going rogue. And why? Because they can. Because they can. So, with regard to the Supreme Court has, I believe, entirely become now a political entity, weaponized to do whatever it is they want to do, right? So, the question is, however, they are appointed for life. I believe that there should be term limits, and I can see a court having as many as 40 justices. Why? I can see justices deciding issues in geographical areas from which they come, right? There are academics writing about this now. Ideas are floating, but we, the people, are only the ones that are going to be able to make this happen, to get our people in the legislatures, in the Congress, and the Senate, to have the courage to get up and say, this is not what we ought to have as a body that is ruling and making decisions that govern all of our lives. Before the court coming up next, affirmative action, I don't know how you feel about it, but they're looking at Harvard, University of North Carolina. My view is this court is moving to say race can never be a factor in anything, saying it's unconstitutional. That's 41 years of precedent saying race can be a factor. You can look at this as part of, for example, admissions in college. My view, the Gang of Six are going to say that's out completely, and watch what happens to enrollment of people of color, particularly black and brown. You're going to see a dramatic drop. That's what they want. And they're looking at all kinds of stuff. You know, that's a whole other discussion about what's coming up before the court. Pay attention. We're screwed as far as when they make their decisions. That's going to be it. But state judges can make a difference in these individual states. For example, on, I don't know how you feel about Roe v. Wade. I'm supportive of a woman's right to choose. But the states can do that. State trial court judges, state court justices can make a difference. That's why it's so important we have this information. I thank you all so much.